morning, guys. It's Kathy. I hope you're doing well. I don't know why my green screen is... All right, there it is, the cat. Oh, good. I knocked my camera out. Sugar. Came back on. So today, we're going to start with Judge Shapiro. And, because Zach likes Judge Shapiro. And I know Zach isn't here this early, but he's going to be here soon, maybe. So, this one's for Zach. So, what we have to decide on this one... There, that's better. What we have to decide on this one is, does the judge believe the story or not? And how is the judge going to rule? Here we go.
So I'll ask you to raise your right hand. Do you swear or affirm, under pains and penalties for perjury, that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God?
Yes, sir.
Okay, you may put your hand down. What is your full legal name?
Jonathan Prescott Wallington.
Okay. And Mr. Wellington, it looks like, in January of this year, you purchased a vehicle from the defendant, Robert Leonard Robbins III. Is that correct?
Yep.
Okay. Did you know Mr. Robbins before the transaction?
No.
Okay. Did you meet him on Facebook Marketplace or some other way?
Correct. Yep. Facebook Marketplace.
Okay. And you indicate in your statement of claim the vehicle was listed as having certain disclosed issues. However, after the purchase, the plaintiff discovered that the vehicle had significant undisclosed defects, including serious engine and transmission problems. Plaintiff further discovered that the check engine light bulb had been physically removed prior to the sale, which masked the existence and extent of these defects. How did you learn that the check engine light bulb was removed?
Yeah, so the day that I brought the car home, I had to drive it from Indiana back up to Michigan where I live. My neighbor across the street is a certified mechanic, so I parked the car over by his house. I have a video of him removing the dash, where we see that the check engine light bulb is not there. We take the left turn signal bulb, plug it in, and then immediately the check engine light starts not just turning on, but it starts flashing. We return everything in the dash back to the way it was. And this was basically because I knew that there were going to be some problems with the car, and I'm willing to repair that and fix that. I do a lot of my own work. But had the bulb been flashing when I was going to pick the car up, I wouldn't have purchased the car. So we returned the dash to the settings, took the bulb back out, put it back into the left turn signal. And then the next day I brought it to the local mechanic basically for a full assessment. And then they also reconfirmed the check engine light bulb was removed, obviously.
He does a lot of the work himself, he says, but he got help to move a light bulb.
And then we also have a full listing of all of the problems that the car had, which was a lot.
And what was the year, make, and model of the car?
It is a Honda CRV, I believe, a 2001 Honda CRV.
Okay. And what was the agreed upon purchase price?
$2,100, I believe, is what we agreed on. Yep.
Okay. And do you still have possession of the Honda CRV?
I do. Yep.
Okay. So it appears to me that, the maximum you would be out would be the $2,100 purchase price. However, under Indiana law, if you have retained possession of the vehicle, the court would have to determine, $2,100 purchase price for a good functioning vehicle, less the value of the fair market value of the car in its current condition. And I mean, even if it's scrap metal, it might be $150 or something like that. So there's some value to that vehicle. So tell me why it would be appropriate to award you more than $2,100.
I think the primary issue is the entire purchase would not have happened had the check engine light bulb, it's standard fare for that to be in place. That's one of the primary safety sensors of the car.
PC.
Let me stop you there. So
Yep.
if the transaction had not happened, you'd have $2,100 in your pocket and you wouldn't have a vehicle.
I would have 24. I would have 24.
17 and 95.
95 because I wouldn't have had to pay for the diagnostic fees or either of the tows to the local dealership, or sorry, the local mechanic and back to my house. It was the day that I was going to drive it to the mechanic, which is also a very short distance from my house. The car wouldn't turn on, so it was dead basically immediately when I by the grace of God, I think I got it to my house. So I would have more than the 2,100 had the check engine light bulb been in the car, because I wouldn't have purchased it.
Okay. Is the car currently running?
No.
Okay. Do you have an estimate for how much it would cost to get the car to be functional?
Yes. Give me one moment. So the I was quoted $12,111 to get it back into functioning. Yeah, like I said,
no one in their right mind would pay 12 grand to restore a 2001 Honda CR-V that they bought for $2,100.
Correct.
Sir, I think there's some value to that vehicle. Whether you sell the tires or scrap the metal, there's some value. I'm going to enter judgment in your favor, but it's going to be for $1,600 plus court costs. That's the $2,100 purchase by less what I believe to be a fair market value of and a 25-year-old vehicle that is not running. So judgment's entered for $1,600 plus court costs. There are things that you can do to collect on that judgment. I always joke that I wish that I had the power to, God bless you, to pronounce a judgment and have the money fall from the sky, but I don't have those powers. So there's something called a motion in proceedings supplemental, which I was talking about earlier in this hearing ship. You're free to file one and get a hearing scheduled, and then you could appear for that virtually again, and defendant, if served, would be ordered to come in. And in that instance, if he didn't come in, he wouldn't just have a default judgment taken against him. He could possibly be subject to a contempt hearing to talk about why he shouldn't be held in contempt for disobeying the court's order to be here. Does that make sense?
It does. Yep. You said it was a motion.
In proceedings supplemental, we often call it a pro sup. It's proceeding supplemental to a judgment. And if you go to the website, there are some forms that pro se litigants can use. We have a standard motion and standard orders that we use setting hearings. They're usually scheduled 5 or 6 weeks down the line. It looks like Mr. Robbins does live in Elkhart, so that should be able to get served by the Elkhart County Sheriff. However, there is a one-time post-judgment sheriff service fee. Last I knew it was $28. If you want the sheriff to go out for this hearing and any future hearings to give notice, that $28 would cover it for forever. But it is a one-time fee that has to be paid before they'll serve the pro sup order.
Okay.
Any questions, sir?
Is that able to be all done through the Elkhart online portal?
I believe so. I'm fairly certain that litigants file pro sup motions and proposed forms of order all the time. Yes.
Okay, now you know what to do if you get a lemon. If you get a lemon, you can get some of your money back, but you got to go to court. So yeah, I have 2 Facebook issue court hearings today, and I can't see out of my one eye, so I clicked the wrong one. This one we're about to do is the one where the judge has to figure out, do they believe him or not?
You want that for MC,
Judge
please?
Link. I love him.
State of Indiana versus Beth Ramsey, 46-04, 2512 CM
3997 and 2512 CM 3085.
Thank you, Your Honor. So if I could address, Ms. Ramsey has another clause where there's a warrant for her under 46D04 2602 CM 394. I had Ms. Ramsey turn herself in this morning, but the jail will not let her post bond or be released because of two other cases. But those other cases, she's not out on bond. She was summoned to court. So I don't know why the jail's doing that. This is a case where it's our position, Judge, that her Facebook account or any other account has been hacked. And these are, she keeps on piling on these charges for invasion of privacy. It's our position someone has hacked her account and they're sending these messages out. I've given Mr. Fidoso some, what I would consider proof of this, but Mr. Fidoso just needs more time for law enforcement to adequately look into these Facebook accounts. But I don't have those means or capabilities of doing that myself. So
she has a protection order on her, and her Facebook account is sending the protected party messages. So they're saying, oh, it was hacked. It wasn't me. The judge has to figure out, was it her or was it not?
asking Judge if you'd please release her on her own recognizance that she did turn herself in this morning. And if we could just continue all three of these cases out to give us some time to investigate this.
Have you reviewed any of that material before today, Mr. Fidoso?
Mr. Pajic did show me that. What was it? Was it yesterday or Friday?
I believe it was last week.
Okay. Yeah, well, Your Honor, and candidly, I don't really understand. I mean, I'm not able to interpret it and tell whether or not what it means. So I would have to have somebody look at it. And that's kind of my next step here. So honestly, I'm not sure how to evaluate the what Mr. Pajic is representing. I'm being honest.
So your client, Mr. Paycheck, has no control over her Facebook account at this point in time?
Correct. She does not, and that's been our position. And what I was hoping for with if the Michigan State Police have access to this, I don't know if they can tell, like, if a message comes from somewhere, like where it was, what Wi-Fi network or where it came from.
Yeah, I'm not sure either whether they can or not. And
guess what? They can. They actually can find out who sent the message. They really can. So if she's lying right now, they can prove it.
that's kind of what I was gonna.
But these charges are based on coming from an account she has, but she doesn't have access to this account. So it's a tough position, and to be candid with the court, there can be 500 more messages that come from this account. She doesn't have access to it. And this was, if you look at my motion, Judge, that I filed when we initially had the first two warrants to recall and issued summons, my representations are the same. As well. So I'd like to get to the bottom of it, but I'm just of limited means to do that.
When were your motions filed previously?
Oh, uno momento, please. My motions were initially filed on January 12th, Judge. Or January 14th, perhaps.
Has Ms. Ramsey contacted Facebook?
I'm sorry that I'm not more prepared to answer this question. I would like to say yes. The problem is she does not have.
Has Miss Ramsey contacted Facebook? Judge, come on. Come on, Judge. You can't contact Facebook or YouTube or TikTok or anybody. You can't contact them.
Recovery, when you change an account, it's like a recovery password or recovery number, all that's away from her. So she doesn't have a recovery.
I understand that, but there's a process that she can at least file something with Facebook to look into it.
I can't answer that question. I know she has a divorce attorney that sent me a long, lengthy message on all this because it stems from a family dispute too. And I have a long message from the divorce attorney. I just haven't had a chance to absorb it all yet.
Well, if what you're telling me is true, then I'm assuming another message is going to come in the near future and she's going to get another charge for it.
Right. And Judge, I don't want to get a timing off here. Last week, I was in jury trial Monday, Tuesday, and Wednesday. She hired me sometime during this time. I think I talked to Mr. Ferdoso either right before or during that time. To be candid, I haven't had time to put this on my front burner. I told her to turn herself in because Mr. Ferdoso, he's not a computer expert either. I try to do what I can to address this. She's not hiding from the court. She's not, like I said, she turned herself in. She's not trying to avoid responsibility. I'm just being as upfront as I can with what our defense and what our position is. And I understand probable cause is a lower standard. There's alleged message or messages that come from this account. I get it, it's a lower standard. That's what I'm dealing with right now. And if she can be released, trust me, I will tell her to do everything she can to contact Facebook and then bring some type of proof to the prosecutor and I into the court to at least let you know what Facebook's response is.
Right, and nothing else. Hopefully she doesn't shut down by Facebook, but
Right.
if she maybe through other avenues proves her identity to them, as this is basically impersonating somehow.
Right.
And
And
I'd be willing to
So where's the divorce attorney on into this?
My client has a battery charge involving the minor daughter. There's also a divorce. The divorce attorney had sent me a lengthy message this past weekend. Like I said, I haven't absorbed it all, and it's kind of exhausting because it's long. It's not like, oh, Scott, this is what happened. So I like to get the bottom of it, and obviously, at the risk of, I don't want to harm my client, but if what I'm saying, based on representations made to me, let's just say they're not true, and the prosecutor can prove they're not true, and it doesn't put my client in a light, that's not going to help her with the prosecutor or with your honor. So I wouldn't, like I said, I wouldn't make these representations if I didn't think there was at least a minimal kernel of truth involved in it based on what I've seen, because she has been making these complaints to me that she doesn't have access to her darn account. And I'm just not adept enough when it comes to Facebook, Snapchat. I mean, I'm still living in 1982. I'm not part of all that stuff. I even do that at a personal level. So
where's the state?
I'd like to see the message. I would also love to see this long letter from the divorce attorney and what it has to say, because if she didn't do it and her Facebook account was hacked, that's a short email. But if he starts piling in excuses and blah, 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 she did it. She absolutely did it.
Well,
and I mean, he can just block that account in one little click. Or the daughter, I don't know. I thought this was against the father, but you just block that account.
Your Honor, I did review, obviously, the police report in the new case. I guess the state's position is that I'm going to try to get to the bottom of this also. And like Mr. Pajek said, if it turns out that these representations are not true and I can prove it, that's not going to be, that will certainly affect the way that the state proceeds. But at the same time, I'm, again, not sure. I'm not able to evaluate this evidence for myself. I need somebody to look at it who actually understands this stuff, and I don't. So I guess the state for now, I mean, I know that the victim has been in contact with our office, and I believe is upset, obviously, about receiving these messages.
Well, if they're from her mother, she.
Well, I mean, I guess. Well, yeah, exactly.
More than upset.
Yeah.
If they're not. Something needs to be done.
Well, and I guess what I'm not sure. I mean, I guess like you know, the defendant says they didn't do it. That's something that's pretty common. So I don't know how to evaluate this at this point, and I certainly do intend.
No, I'm not asking you to evaluate it. I'm asking you what your position is on releasing Miss Ramsey OR again.
Well, Your Honor, I guess the state would prefer that there'd be a reasonable bond, because I can't just take her word for it that the Countess Act, and at this point, that's what I feel like I have is her word for it. So, but I take seriously the possibility that that's a thing that does happen. So I do need to look into that. I guess that's where I'm at.
So what can your client post, Mr. Paycheck?
Judge, I appreciate the question, but before I answer your question,
You're going to pose a question?
I'm gonna pose a statement, I guess. I'm sorry. I just find that my client turned herself in. She's not a flight risk. This is based on technology on an alleged message. So I don't know.
I understand that, but that's half the equation on bond.
I just don't know what the purpose of her posting a bond is. But to answer your question, if the prosecutor thinks it's going to make a big difference in this world, if she posts a bond when she turned herself in, I'd say maybe $500. She's not hiding from anyone. She wants to resolve this.
All right. I can live with the 500 cash. Aggregate for all matters.
John's back. Hi, John. Yahoo by far was the best messenger back then because it had this buzz option where you can continually buzz someone. It was great.
April 21st.
I appreciate this, that we could have all these tracked, and I hope you get the bottom of this. And
So you are entering in 2602 CM 394, correct?
yes, this is on 394. Yes, sir.
You're waiving initial hearing.
Absolutely.
All right. Preliminary plea of not guilty entered on behalf of Ms. Ramsey to all charges in 2602 CM 394. Initial hearing waived by counsel. All matters reset to April 21st, 2026 at 12:45 p.m. She'll be released on $500 cash bond aggregate for all matters.
The best messenger ever was Paul Revere. Salty's right. Not arguing. I like John Link, but he did not believe that story. Can you believe that? Can't believe it.
Thank you. Please be seated. All right, ma'am. Are you Jill Knesny?
I am.
All right. This is 46 DO2 2311 F2 1639. Get your file up here. All right, this is an initial hearing on a petition to revoke your probation. We have Ms. Konechny present by video from the LaPorte County Jail. We have Mr. Ferdoso visiting us from prosecutor's office and Ms. Swanson from probation. Ms. Konechny, I'm going to tell you what your rights are, and the state of Indiana is going to tell you what the allegations are, okay?
Okay, thank you.
Can you hear me okay?
Yes, I can.
All right, you have the right to have
Linus, there's a slight trigger in this one for you. I'm so sorry.
an attorney represent you in this matter. If you want an attorney and you cannot afford one, the court will appoint an attorney to represent you at no cost if after this hearing you're determined to be financially unable to hire a lawyer. You cannot be compelled to make any statement or testify against yourself at this hearing, and you have the right to remain silent, but please be advised anything you say can be used against you. You have the right to have a hearing on the allegations made in the petition to revoke your probation. At that hearing, the state must prove the allegations by a preponderance of the evidence. Now, that's a lesser burden of proof than a criminal case. Do you understand that?
Yes, I do.
Do you understand what your rights are?
Yes.
Yes?
Yes, I do.
Okay. Please pay attention. Mr. Ferdoso is going to tell you what the allegations are.
Thank you, Your Honor. The first petition for revocation of suspended sentence alleges that the defendant in this action, Jill Konechny, has violated the terms of her probation established as the condition of the suspension of her sentence. That was imposed by this court on July 19th, 2024. The sentence was suspended on condition that the defendant obey all the conditions of probation, but she has violated certain of those conditions as follows. Condition number 1, which is to refrain from violating any law, state, federal, or local, and to advise the probation department within 24 hours if charged with a misdemeanor or felony. The specific allegation is that on or about the 18th of November, 2025, she allegedly committed the new offense of harassment by means of a telephone call, a Class B misdemeanor. That charge is filed in LaPorte Superior Court 4 under cause 46D04-2512 CM 2961.
All right. Do you understand what the allegations are?
I'm unaware of them. I didn't know I had.
But you understand what he's just said, though?
Yes, I understand what he said.
All right. Do you plan on hiring an attorney?
I am unemployed. I just finished 16 months of cancer treatment. So
Okay. And
been trying to stay home and stay out of trouble. I had my car window broken out. I'm so lost by this whole accusation. I'm sorry.
that's okay. So you have, at this point, don't have the funds to hire an attorney. Is that correct?
No, I'm unemployed.
Okay. Knowing your history, I'm going to appoint the public defender's office to represent you. Do you have any money you can post towards a bond?
I had my mom pay $300 last week to get me out of here.
Okay.
I mean, I can, if it can get me out of here, I can find money.
This woman is about to make her jail time much, much, much worse.
I don't belong here.
I'm going to set this at the standard bond for an F2, which is probably not going to get you out anytime soon. We're going to set this over for a couple of weeks so we can get you back here with your attorney.
We could do March the 27th.
All right. We're going to set this over to March 27th at 9 a.m. Ms. Konechny, if you do bond out, you're ordered to be here in Michigan City on the second floor, March 27th at 9 a.m. If you do not bond out, we will have you over here, okay?
Mm-hmm. And what is the bond?
I'm going to set it at the standard amount. I have to look that up just to make sure.
I
Yeah.
believe the conviction was for a 5, if that makes sense.
Oh, it's for a 5?
Yeah.
Conviction was a 5. It was
Okay.
originally.
All right. Then I'm going to set it for a standard for a 5, which is $15,000 cash to the clerk of the court.
15,000?
Yes, ma'am. Your attorney, you can argue with your attorney in a couple of weeks to try to get that reduced, okay?
I have cancer. I cannot be in here. I'm suicidal. These accusations are absurd. I did nothing. I swear I did nothing. I just want to clear my name.
I understand that, ma'am. I'll take another look at your file, but right now that's what I'm till I
If
look at
I'm in here,
everything.
I will kill myself. I cannot, this is not me. I've never, ever, ever been in trouble. I'm 45 years old. I made one mistake.
Thank you, ma'am.
I'm dying.
We'll see you in a couple weeks.
$15,000.
Now, because of that last sentence, she's going to be probably a little bit restrained and in a different unit and watched. And now it's going to be way worse for her in there. Way, way, way worse. But you can't say that to a judge. You can't say that in front of the officers. Okay. This lady's slightly worse.
Destiny Jean Marie Clanton, 2210F61353.
Yes, Your Honor.
Good morning, Ms. Clanton. No, I don't see Mr. Pajic. I think he's your attorney. You were supposed to be in court.
Yes, Your Honor. I'm currently dying of an infection in my finger. I just recently lost it, which is currently why I'm ill right now, and I'm waiting to go back to my room. I've been very in and out of the doctors. I just lost my finger and I have something in my finger growing like legitimately out of it, Your Honor. I don't know if you can see it or not, but there's legitimately something growing inside my, so it's been in and out of the hospital, in and out of medication. This place hasn't given me my medication, so I've been really in and out of
So
it.
when was the last time you spoke with Mr. Pajic?
Mr. Pajic, probably about less than a month ago.
Linus, listen. It sounds like from a lot of the court cases that I hear, if you get cancer, you're going to go to jail. Because they do often say that. Just like if you are about to get a job, you're going to jail. So Linus, I need you to spend all of your time in church right now so that you don't go to jail. Don't say that in front of a judge. We don't want you to.
Okay.
I literally just got out of the hospital legitimately a week ago.
So Ms. Balestra, you've got a recommendation for the second revocation.
They're trying to put me in county for a year.
180 days, the Port County Jail, is that right?
Yes.
Okay.
And I'm not going to make it with my health the way it is, ma'am. I'll do anything, and I know I was wrong, and I would even do home detention if I have to.
Just hold up.
But I'm just really scared of dying in this place with an infection that I can't. And it's already happened before. I just lost my finger, ma'am.
Terry, talk to Linus. Teach her how to be a good girl.
Are we expecting Mr. Pajic? Yeah, he may not know about this. Were you just brought in on this warrant? Ma'am, were you just brought in on this warrant?
Yes, I just got picked up. Going to the doctor, yes.
Okay. All right, and when did you go to the doctor?
Yesterday. I was on my way to the doctor, ma'am. And I got stopped on the side of the road, literally legitimately stopped on the side of the road and picked up.
Okay, here's what I'm going to do. I'm going to reset this for Monday morning so that we can have Mr. Pajic here.
Yo, send that right now.
Thank you.
Talk about my dedication because I was 30-40 minutes late. I got Monday morning. Here it comes.
Thank you, Your Honor.
You're welcome.
This is Destiny Clanton, 2210 F6 1353.
Yes, Your Honor. Hi, I'm Destiny Clanton.
So I've already told you to look it up. Okay, great.
All right.
Your Honor, I just wanted to let you know, I am currently going through a lot of health problems, and I was picked up going to the doctor for my health problems. That's how I got picked up. So I was doing what I needed to do and going to my doctors, and I just lost my finger with the blood disease and all. I'm currently going through a lot of problems, and I take $107 injections right now that I can't, they're not giving me none of my medicine here. And I'm really scared. I lost my thumb. I don't know if you can see it or not, but I did lose my thumb.
Okay, Ms. Clanton, does Mr. Pajic represent you?
I haven't talked to him in a minute because I've been sick, ma'am. I literally almost died almost 6 months ago, and I'm currently going through health problems right now with my thumb.
This is Scott Pajek, Your Honor. Who is this?
I have,
Oh, good morning, Mr. Pajek. We
I
have
haven't talked to him in a
Destiny
minute.
Clanton here.
Yes,
Third revocation.
I have
Okay.
not.
I apologize, Judge. I am not familiar with this case. Destiny, I'm sorry. I don't know if I've been hired on anything, but I just want to let you know I am here. I'm not familiar with this case, Judge.
Thank you. I know that
I'm
we
currently
saw-
going through health problems, paycheck, and I just lost my thumb, and I'm still going through blood infection pills that they're not giving me here. Like I literally almost lost my thumb. I don't know if you can see it. I don't know. But I literally just lost my thumb and I was going to the doctors, and that's the only reason why I missed court was because I was too sick. And they're not giving me none of my medicine in here, and I feel like I'm legitimately dying. And they're telling me that there's nothing they can do until I fill out a form and they still have yet to give me the form. And I've been here since Thursday. Like, ma'am, I'm really scared. This is the one time in my life where I actually haven't done anything wrong. I'm actually trying to sit down.
Clanton, we talked about this Friday, remember?
Yeah, I know.
Okay, so just take a breath, all right?
I'm trying. It's just I feel so horrible. They're not giving me none of my medicine. And it just sucks, man. I feel miserable.
Ms. Earn, have we had the third revocation?
I don't believe
You
so.
are a
No,
brat.
no.
Okay, so I want you to listen to the prosecutor, okay? Miss Clanton, the prosecutor is going to read you the basis for this revocation.
Please, the court, she was put on probation on February the 27th of 2024, and she executed written conditions of what was expected of her. Condition number 7 states that you shall not use, purchase, or possess illegal drugs or illegally obtain prescriptions.
And I was honest with my
Visit
probation
any
officer.
place where illegal drugs are used, possessed, sold, or dispensed unlawfully, and provide verifications for any prescribed medication.
And I've been doing that. And
Tested positive for illegal drugs,
Clanton.
methamphetamines, no prescription, and amphetamines on the 22nd day of December 2025.
I called my probation officer and I was honest with her about it. Ma'am, before anything, I was.
Two previous petitions based on.
The second petition was number 4, which state you shall report to probation appointments as directed by probation. If your sentence indicates a term of incarceration, report to
And I
probation
have.
within 3 working days of your release. Defendant failed to report to probation as directed.
No, I've went to probation. I called my probation officer and I did go to my probation. The only one I did not go to was my court date.
You have,
And the one probation meeting was because I was sick and in the hospital in Indy.
Miss Clanton.
I was in Indy.
I'll give you an opportunity to say anything else you need, but right now, please don't interrupt everyone when they're talking.
Yes,
Ms. Earn, have we settled the first and second petitions yet?
I'm looking on. I don't believe so. I believe they're still pending.
Okay.
Yes, Your Honor.
Judge, the first petition alleges, again, illegal drugs, methamphetamines and amphetamines. No prescription, March 14th, 2025.
But she can't afford a lawyer. But she can afford drugs.
I was honest with it. Yes, I know.
All right.
And I will even go to rehab if I have to. I will do what I have to do, Your Honor.
All right, so are you going to be hiring an attorney to help you on these matters, or are you going to need a public defender
I'm gonna
appointed?
need a public defender, ma'am, because I don't have any money like this. My health is like taking everything I have out of me. I don't have anything. I still got to get on disability for my health.
What is a good telephone number for you?
Right now I only have my telephone number and I'm currently in here, but 219.
Okay, let's start again. 219.
The judge can't see your comments, but we are all very judgmental.
And his name is John Harris. He's on my bond slips. He's a good number you can
Whose
call.
number?
John Harris. He's on my bond slips. Because the only other number I have is with me in county, ma'am. So I don't really, both my parents are dead and I have no family. This is why I'm very
What is your address again?
617 Michigan City, Indiana, which is John's address.
State want to be heard on bond?
Judge, this is her third probation. She was third petition to revoke probation.
Only because of my health.
March of 2025, and then 9 months later, another same issues, methamphetamines and amphetamines. We're asking for $1,000 cash bond. We're gonna be looking at executing her suspended sentence.
All right, I am appointing you a public defender, Ms.
They muted her.
Clanton.
She's done.
Gonna set a $750
Kelvin,
cash
I'm at the
bond.
lowest in
I
society.
will set this pretty quickly. I'd like the public defender's office to talk to you about getting into rehab. So I'll set this for another hearing on Monday, March 30th at 9 o'clock.
Show her your thumb again. Quick.
Thank you.
Quick. Oh, too late. She doesn't know she's muted.
State of Indiana versus Bridget Brown, 23-0.
That poor thing. I mean, she still has a lot of her thumb. I mean, okay. No, I don't want to do that. Let's do 2 high bonds. I just got there's nothing crazy in this clip. The judge just doesn't like PR bonds.
Yes, I understand. Do you have any questions about your rights? No. Do you also have the right to know what you're accused of? The state of Indiana filed a charge against you on March the 3rd, 2026, alleging you committed the offense of stalking, a level 6 felony. A level 6 felony is punishable by 6 months to 2.5 years in prison and a fine of up to $10,000. The charging information, omitting formal parts, reads as follows. On or about February 26, 2026, in Elkhart County, state of Indiana, you did stalk another person, to wit one Sarah Lemon. Sir, do you understand what you're accused of? Yes. I will enter a preliminary plea of not guilty on your behalf. That becomes a formal plea of not guilty after 20 days. There are certain motions and defenses that must be raised in that 20 days, or they will be waived. Do you intend to have an attorney represent you in this case?
No, I need a public defender.
Okay, are you currently employed?
Yes.
And how much money do you make?
I make about $900 a week right now.
Okay, do you have children that live with you that you support?
No.
Okay, do you have a rent or a house payment that you make?
Yeah, I pay rent and bills.
How much is your rent?
Rent's about $700 a month, and yeah.
Okay. And I will appoint the public defender's office to represent you, but you'll likely be required to reimburse for at least a portion of that expense at a later time since you are employed. The next issue you need to address is there was no contact order that I believe was already served on you at the jail. Is that correct?
Yes.
I'm still going to read that to you in court so that there's no confusion about it. You are ordered to have no contact with Sarah Lemon, and that is in person, by telephone or letter, through an intermediary, or in any other way, directly or indirectly, except through an attorney of record, and that applies to while you are released from custody or if you are in the jail. This includes but is not limited to acts of harassment, stalking, intimidation, threats, and physical force of any kind. Further, you shall not visit the following locations during the period of your release. Anywhere you know Ms. Lemon to be located, or within 1,000 feet of Ms. Lemon. Do you understand the no contact order, sir?
Yes, I do.
Okay. I'd like to read your future court dates, and we'll give you those in writing as well. You will have an attorney conference date of April 15th, 2026 at 1:00 p.m. An omnibus date, which is just a calendar date for your attorney. It's not a court date, but that is April 20th, 2026. Excuse me. Your plea bargain deadline hearing is June 1st, 2026 at 8:30 a.m. Next issue we will address is the issue of bond. I'll call on the state first. Mr. Gruber.
Your Honor, the state is concerned at some of the, I guess, the escalating behavior and the threats that women in this case, not just following her, but as I said, making threats to her physical safety. The state is asking for an elevated bond of $25,000 10% cash.
Thank you. Ms. Faulkner?
Thank you, Your Honor. Your Honor, Mr. Berry scores a low IRAS score. He has no prior failures to appear. I certainly understand that the state wants to argue the facts as alleged in the probable cause affidavit in this case, but they are merely allegations at this point, and Mr. Berry is presumed innocent. We would ask the court to consider the fact that he is a drug court graduate. He's 3 years sober. He has a good job at Thor that is still available to him, and would ask the court to set a bond in accordance with the recommended bond schedule for Elkhart County. Thank you.
Thank you.
So it's not really, okay, there's 3 different ways, I think. Okay. You can pay the court the full bond. Okay? Or you can pay a bondsman. You can get a bond from a bondsman, give them 10%. They pay the court the full amount. But you don't get that 10% back. They keep it no matter what happens. But then some of these jails and courts do a third way, where they let you pay 10% to them, to the jail, and then you do get that money back. I think they take out some fees and stuff like that, but you do get that money back. Not all jails or courts do that, but that's the 10%.
Based upon the probable cause affidavit, court certainly notes concerns regarding safety to the community, specifically the alleged victim in this case, related to, as indicated by the state and also as indicated in the probable cause affidavit, allegations of escalating behavior with the defendant being the aggressor. Also based upon the defendant's prior history, which includes pretty intensive supervision. There is an allegation that possibly was under the influence of at least alcohol in this situation as well, which is could be an issue based upon the defendant's prior history with intensive services. Again, the major concern though is of course the escalating behavior as alleged in the probable cause affidavit. The court is going to set an elevated bond in the amount of $15,000. That's a 10% cash bond. The court is also going to set the level of supervision on pretrial services at level 2. Sir, we're going to give you the order and conditions of pretrial release. You will be required to sign that document today in court, and we are going to give a copy for you to take with you as well. Level 2 supervision in essence means that you need to attend at least one face-to-face appointment per month with pretrial services, participate in at least one telephone appointment per month, and you will undergo criminal history checks every 30 days. You need to contact, if you do bond out, you need to contact that program within 2 days of your release. A violation of that program would be a violation of your bond and could result in your bond being revoked and you be placed in the jail until your case is resolved. So again, the bond is $15,000, 10% cash with a level of supervision at level 2. Sir, do you have any questions about anything that we've discussed today? Okay, we will have you look at that order and sign a copy to return to the court and then give you a copy to take with you.
We don't see 15,000 a whole
Can I
lot
stand
in
this on?
CRs.
Oh, never mind, I'm good. Sorry.
I would absolutely show it. I would, absolutely.
Okay, good luck, Mr. Berry.
Thank you.
You on March the 4th, 2026, alleging you committed the offense of domestic battery, a Class A misdemeanor. A Class A misdemeanor is punishable by up to 1 year in jail and a fine of up to $5,000. There is also a page 2 of the charging document enhancing the domestic battery to a level 6 felony, which is punishable by 6 months to 2.5 years in prison and a fine of up to $10,000. The charging information omitting formal parts reads as follows. On or about March 2nd, 2026, in Elkhart County, state of Indiana, you did knowingly touch another person, to wit, Brittany Rabel, a person who is a family or household member of yours, and you did so in a rude, insolent, or angry manner. And page 2 indicates that at the time you are alleged to have committed the offense, you had a previous conviction for a battery offense included under Indiana Code 3542-2 et sec. To a battery judgment of conviction entered on November 6, 2023 in the Morgan Superior Court 2 in Morgan County, state of Indiana. Mr. Honorable, do you understand what you're accused of in this case?
Yes, ma'am.
I will enter a preliminary plea of not guilty on your behalf.
Judge, his name is Mr. Honorable. Give him a PR bond.
That becomes a formal plea of not guilty after 20 days. There are certain motions and defenses that must be raised in that 20 days or they will be waived. Do you intend to have an attorney represent you in this case?
Yes, ma'am.
Are you able to afford an attorney?
No, ma'am.
Are you currently employed?
No, ma'am.
Do you have assets worth $1,000 or more you could sell to hire an attorney?
No, ma'am.
Okay, I will appoint the public defender's office to represent you. Next issue to address is there was a no contact order that was filed in this case and signed by Magistrate Burton, which indicates you're ordered to have no contact with Brittany Rabel, and that is in person, by telephone or letter, through an intermediary, or in any other way, directly or indirectly, except through an attorney of record, and that is while you are released from custody pending trial or if you remain in custody at the jail. This includes but is not limited to acts of harassment, stalking, intimidation, threats, and physical force of any kind. Further, you shall not visit the following locations during the period of your release, wherever you know her to be located or within 1,000 feet of her. Do you understand the no contact order?
Yes, ma'am.
We'll next address the issue of bond, and I'll call on the state of Indiana first. Mr. Gruber.
Thank you, Judge. In looking at Mr. Honorable's criminal history, it is particularly lengthy. I guess most concerning to the state is that he was out on bond for a domestic battery previously. The state had asked for a $10,000 bond in that case. Bond was set at $6,000. And this new offense was committed while he was out on bond, and it is against the exact same victim. The state has filed a motion to revoke bond in the prior case, but based on his lengthy criminal history, his history with this particular victim, the fact that this occurred, while he has a pending felony case with this victim, the state's asking for a bond of $50,000. 10% cash.
Thank you. Ms. Faulkner?
Thank you, Your Honor. Your Honor, Mr. Honorable is asking the court to consider allowing him to post a $10,000 surety bond. He has ties with the community. He has been at the same residence for 8 months. Still has a job available to him at Mosh Concrete. And it's a moderate IRAS score. So we would ask the court to consider something that he can afford to post.
Thank you. Court is going to set bond at $50,000 surety. There's an elevated bond. However, the court is setting the bond that high, considering you're already out on bond for an offense alleged to be involving the same victim, also is a felony charge that you are out on bond for. Again, that's $50,000 surety. I'm going to set the level of supervision at level 2 on pretrial services, which means that you shall attend at least one face-to-face appointment per month with pretrial services, participate in at least one telephone appointment per month, and undergo criminal history checks every 30 days if you do bond out. Mr. Gruber, is the motion to revoke bond set for hearing?
That's a good question.
What was the question?
If the motion to revoke bond in the other cases.
It's set for hearing on March the 24th.
Okay.
Well, I was just going to add it to the court case, but Superior Court 1 will take care of that.
50,000. Finally, finally. Thank you, Judge. Thank you. Let's do this one. It's what this guy did that is the reason I got this clip.
Thank you, Your Honor. This is State of Indiana versus Joseph Hawes. The cause number is 64D01-2603F52350. Defendant appears in court in person by video conferencing, is here with counsel, Mr. Jesse Harper, also by video conferencing. State of Indiana by Gary Gurman.
Morning, Mr. Hawes.
Good morning.
Good morning.
Ruby, I really have missed you. How are you feeling? Are you out of the woods with your back and everything?
Your Honor.
You can hear us, Mr. Hawes?
Yes, I can, sir.
And you've got us okay, Mr. Harper?
I do, Judge. Thank you for allowing me to zoom in. I apologize. I was in LaPorte County this morning. I did not know if I could make the hearing.
Oh, absolutely. I'm glad to have you. Mr. Hawes, first I'm required to advise you of your various rights in this matter. You have the right to hire an attorney to represent you. You have the right to have an attorney appointed to represent you if you cannot afford an attorney. You have the right to a public and speedy trial by jury, and you have the right against self-incrimination. That means you cannot be forced to make any statement or testify against yourself in any hearing or trial held in this matter. Do you understand those rights as I've just gone through them?
Yes, sir.
And so you've been charged here with one count, criminal recklessness, a level 5 felony. This cause states that on or about March 2nd, 2026 in Porter County, you did knowingly or intentionally, recklessly perform an act which creates a substantial risk of bodily injury. Specifically, they say you fired rounds from your front porch towards the roadway and residences south of the roadway. And by shooting a firearm into an inhabited dwelling or other building or place where people are likely to gather. Do you understand the allegations in count 1?
Yes, I do, sir.
And it's charged as a level 5 felony, which carries a possible sentence of 1 to 6 years in prison and up to a $10,000 fine. You understand that possible penalty?
Yes, sir.
As required by statute, the court will enter a preliminary plea of not guilty for you on count 1. You have Mr. Harper engaged in the case. Looks like we do have a pretrial release report. Did you get a copy of that, Mr. Harper?
I did not, Your Honor. I have had the chance to speak to Joe. I've spoken to his wife on numerous occasions. I do know and I believe that Joe has absolutely no prior criminal history. He has lived in the area for approximately 20 years plus. Joe served as a Navy SEAL for 22 years. Subsequently, he was a trainer of various SWAT organizations and law enforcement organizations within Northwest Indiana. As Your Honor indicated, we would be entering a not guilty plea. We would respectfully request a $2,000 cash bond on this matter, Judge.
Okay, yeah, I was going to notify you that they set his pretrial services report, his IRAS score at 0. I think I might have set a $2,000 bond already. Let me see. Yeah, that's what I set. So we'll maintain the $2,000 cash bond on the request of counsel. There wasn't no contact order entered in the case, Mr. Hawes. Have you received a copy of that yet, sir?
No, sir. If I can say so, when I was home.
No, Joe, I don't want you talking about the case right now, okay?
Okay, but he's asking me something and I'm trying to.
No, Mr. Hawes, I'm telling you something. I'm telling you that there's a no contact order that's in place that protects a person named Darcy Coots. So you're not to have any contact with Darcy Coots. I'll make sure that they get that to you before you release from jail today when you bond out so that you can receive your copy and be served with that. Do you know who that person is?
Yes, sir.
Okay, so you need to not have any contact with them or you can be charged with invasion of privacy, which in your situation would be charged as a Class A misdemeanor, which could carry up to a year in jail and a $5,000 fine. You understand that possible penalty?
Yes, sir.
Okay, sir. Well, I'm going to set you up for a couple of hearings. Mr. Harper, do you have your calendar?
I do, Judge.
We were going to use May the...
Brent, I'm sorry you don't feel good. If you're not hungry, you don't feel good.
11th for his omnibus
Okay.
and June 8th for his pretrial conference.
Sounds good, Judge.
Want to do them both at 10 or 11?
11 would be perfect, Your Honor.
Okay, we'll do them at 11 o'clock. And Mr. Hall, you're ordered to appear back here May the 11th at 11 a.m. and June the 8th at 11 a.m. Do you have any questions, sir?
Yes, sir. If it's okay with my counsel?
Yeah, you can ask a question, Joe. Just don't talk about the case.
Okay. Sir, I was just wondering and throw myself at the mercy of the court because I never got a speeding ticket.
No, Joe, that's about the case. That's not a question. Okay. We're going to have time to talk about this.
And Mr. House, we already considered the fact that you have a clean criminal record and determining the amount of bond, which was $2,000 as your counsel suggested. Okay.
Okay.
So we already took that into consideration for this part. Okay.
Yes, sir.
All right. And with that, we'll see you back here on May the 11th at 11 and we're adjourned.
Okay. Thank you.
And I'll call Tammy. I'll call your wife, Joe.
Okay. Thank you.
Thank you, Your Honor.
Marshmallow in the form of a little chick with sugar all over it. So I don't know. He was a serviceman and he shot into a house. I just feel like I don't know. I don't know how it works, but I feel like the military should be handling this one. Like just send it back to the military courts and let them decide his fate. I don't know if they're worse or better. But they taught him how to use a gun. Alright, so that guy shot into his neighbors. How long is this? Let's do this one. This one's a little worse toward thy neighbor.
And we're looking at resolving cause number 71B01 2510 F6776 as well as 71B03 2510 CM 2146. Good morning, ma'am.
Good morning.
Ms. Skidinsky, are we ready to proceed with sentencing for Ms. Burrow?
Yes, Your Honor.
Okay. And did Ms. Burrow have an opportunity to review the pre-sentence investigation?
Yes, I sent it to her over at the jail.
Great.
So before we find out what this guy did with his neighbor, I need to know with your peeps, guys. Your peeps. Do you eat them fresh out of the package? Or, like 3 days out of the package where they're harder? I can't think of the word. I'm looking for a word that's gone. Fresh or, I don't know. Someone fill in my word for me. I eat them. I open the package as soon as I get them. As soon as I get them home, I open the package. So they start getting harder.
And were there any errors or corrections that need to be addressed?
No.
Okay. I had a question before we get going. Were there any days of credit that were to be assigned to the CM 2146 cause?
I was just thinking that, Your Honor. There were 2 days of credit. Because I didn't get that report.
Okay. All right. And there were 144 days assigned to 2976, correct?
Right.
Okay. All right. I want to make sure we're all on the same page on that. Are there any victims to testify in this matter?
No.
And the defense doesn't have anybody? Okay. Then we will proceed such that your attorney will have an opportunity to speak, make her recommendations and argument, then the state, and then you can address the court if you'd like to. Okay. So, Ms. Skidinsky, the floor is yours.
Thank you, Your Honor. As you referenced, she does have 144 days of credit on the felony cause in this matter, which we acknowledge she does have prior criminal history. But looking through it, I would just note that I think it's substance abuse related. She probably does suffer from substance abuse disorder. And again, on this cause, she was heavily intoxicated. And I think that likely her saying things and winding up in this situation. And encouraging to me, I've seen her come from when I first met her. I think she's come a really long way to where I see her now. But she is open to counseling and she's already taken it upon herself. She completed the Jails to Jobs at the jail. It's through Notre Dame's Institute for Social Concerns. She did.
See, now that right there, first off, thank you so much, Tina, for gifting Drunken Smurf a membership on Twitch. I appreciate it. That right there makes sense to me. What she just said. I want to say this in a way where I don't offend someone, which I'm going to, but I don't mean to offend someone. A lot of the classes, the courses, the treatment that people go through for the drugs, crime, violence, whatever, they're all church-based. This is a program from Notre Dame. A college, a university, created this program to teach someone. That makes sense to me. Like that makes sense that you get a university to figure out the best way to teach these people what they need, what classes they have to go through. If we're sending all the criminals to classes now, you're a criminal, you have to take this class and this class and this class and this class. The classes should be from a university where they actually teach you. Yes, you're right, Kelly. You're right. Notre Dame is Catholic University. It's still a university and not a church. It's not just a church telling these people, how to live a better life. Because, I don't know. I'll stop there. But that made sense to me.
Last month, and she also did completed Getting Ahead While Getting Out. So she has taken it upon herself to try to make her life better and move in a better place. She also, while at the jail, applied for the YWCA and has been approved there. She just needs to get these cases resolved until she can go there, which I find encouraging because then she can get treatment that she needs and have stable housing. She has shown a good ability to be employed. She was at Wendy's since 2024. And again, she did take responsibility for this cause, Your Honor. I'm asking that you give her a chance. I know she, again, has criminal history, but she unfortunately has been denied for community corrections due to that Elkhart County case. That cause was, again, substance abuse really that she was on in their drug court programming and a warrant was issued. So I just would like to see some sort of sentence that we can faction where we give her the services that she needs, but it seems like she is taking steps in the right direction.
Thank you, ma'am.
Maria, do you guys
State your thoughts.
Trying to take notes. The third crime is
Judge, shut up. Maria, do you guys have peeps there too? Do you have peeps?
There's the 4 prior felonies. There have been a variety of violations of probation in the history. There is that pending warrant out of Elkhart County. She is at a high risk to reoffend, and looking at the order of the cases, there was being released OR on the misdemeanor case and then the very next day committing this offense. That is a concern for the state. It just seems like the choices are not adding up to success here. So the state recognizes the substance abuse disorder. The state recognizes that that she has her GED, that she's been approved with the YWCA, that she's accepted responsibility. But I think looking at the aggravators of the criminal history and kind of the sequence of events of the case, it does not seem like probation alone is a sufficient sentence. It doesn't seem like it does well with the track record that we have. So the state's request is on F6 976, a 30-month sentence, 12 months of that executed to St. Joseph County Jail, followed by 18 months suspended to probation. And for the misdemeanor case, the state would leave that to the court's discretion.
Thank you. Ms. Burrow, anything you want to say?
I'm just ready to turn my life around. I'm ready to get the help I need. I got 5 kids. I want to get back into my life.
I'm ready to turn my life around now. I already have 5 kids, but now I'm ready to turn my life around, Judge.
You're also the same age as the other gentleman I just spoke to. I said, you're old enough to know better. So you know, that's a big step. So here's the thing though, I mean, I think you recognize this. Having the mindset and the desire to turn your life around is one thing. Having the tools to do that when you're fighting addictions, that's another thing, right? And you're ready to work on getting those tools. And I see that. So that's encouraging. So what we're looking at is on cause number 976. The mitigating circumstances are that you pled, that you're seeking counseling, and that ostensibly nobody was physically injured here. On the flip side of it, you've got that criminal history, doesn't speak well for you, that you were on bond and you were on probation before, you've got all these violations, cases pending in Elkhart County, and the nature and circumstances of the case. I mean, it's one thing to be intoxicated and be a danger to yourself. When you're turning on the gas and threatening to blow up a multi-family dwelling, and by the time police officers, did you read the report where by the time the police officers got to you, your lips were blue from a lack of oxygen? You were on the verge of killing yourself, much less anybody else. So that's a tough spot for you to be in. That's an aggravating circumstance where a significant danger to others that night, including yourself. And I hope that it was a misunderstanding. There was a thing in the pre-sentence investigation where they asked you about your
You hope it was a misunderstanding, Judge?
concern for others. And you said, no, I'm not concerned for others. I hope that's a misunderstanding. I hope that's not how you feel, because while that would track with the activities of that night, I don't see that as a pattern recurring in your life. And I hope that's an anomaly of a misunderstanding. The aggravators do outweigh the mitigators, but for the fact that you've got 144 days of credit, you would be going to be incarcerated for a longer period of time, okay? So what I'd like to do with the party's permission is apply the 2 days from 2146 also to 976. Does anybody have an issue with that?
No, Your Honor.
Okay, so we'll make that 146 days of Class A credit on 976 to apply towards a 12-month sentence, which means you'll have a short amount of time left. Hopefully that the place at the Y will be available for you. Give it a little lead time there. Because I don't want you to be turned out on the street and left to your own devices and without support. We're not done with you yet. We're not trying to just be rid of you. We're not giving up on you. Don't give up on yourself, okay? The rest of this sentence, that's the punishment part of the sentence, is that jail time. The rest of the sentence is geared toward helping you have those tools and do better. Because the balance of after 12 months, it's a 30-month sentence total on cause 976. The other 18 months is going to be probation, supervision. And they'll do an IRAS and mental health and substance abuse assessment, 2 different assessments to make sure that whatever issues are in play, we're going to work to address those, okay? You'll follow through the recommended counseling from probation. You'll also sign the leases for any counseling that you're already engaged with or you've already done. So probation knows about all of this. We can sort it out and make sure we're not reinventing the wheel, but not also leaving anything unaddressed that we should be addressing, okay? So I hope you understand the spirit in which that's offered. No restitution was requested. Is that correct, State?
Yes, Your Honor.
Okay. So there we are. The no contact orders will remain in place for those other former co-tenants with you. So don't have any contact with them. And then we will waive fines and court costs. The only costs that you will have associated with cause number 976 will be.
Well, you should make her pay for all the therapy. Everybody who lives in that apartment complex needs drop bear. Multiple personalities, I feel, is a sign of intelligence.
Probation fees when you get there, okay? Because by then you'll be employable and be able to work to chip that down. You won't be having a big number hanging over your head, okay? Then I think that resolves 976, correct, everybody?
Yes.
All right, and then consecutive to that sentence on cause 2146, that class A misdemeanor, your sentence will be 6 months to probation. Okay, so you'll have a total of 24 months of probation after you finish your 12 months of incarceration, which you're almost done with. I will waive even the probation fees on that one because A, you're already being assessed probation fees, and the only fee you'll have when you continue on that is just the monthly probation fee of $15 a month. Okay?
Almost, right.
No other
Drop
court
there
costs or anything
almost
else.
seems like a great concept.
And those causes will be consecutive, and all of this will be consecutive to anything that happens to you down the road.
He would need
Okay?
a really cute dog to push.
Am I missing anything?
I don't believe so.
Stephen, am I missing anything?
I don't believe so.
All right. So I have here two separate sets of rules of probation because probation wants separate causes.
When your multiple personalities start talking to each other, then you're in trouble. Normally they stay separate. They don't normally talk to each other. Do 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 la la pow. Here we go. Judge Hurley. Be right back.
Oops. This is 25 F2 31, State versus William Easley. Good morning, Mr. Easley.
Good morning, Your Honor.
We're set for sentencing in this case. Are we prepared to proceed?
Yes, please, Your Honor.
All right, so in this matter, we had a plea to count 1, dealing in a narcotic drug as the lesser included level 3 felony. There's a 9-year cap on any executed sentence. Any weapons recovered at the time of this offense will be forfeited and disposed of in accordance with statute, and the parties are otherwise free to argue. And so, Mr. Easley, I'll let Mr. Masters speak on your behalf first, then the state. If there's anything you wish to say, you'll have an opportunity to as well.
Thank you, Your Honor.
Mr. Masters?
Thank you, Your Honor. If you will forgive me, I would like to begin by reading a letter that I received this morning. It is written by Pastor Jason Douglas of Liberty Ministries Incorporated, and it's addressed to the Honorable Presiding Judge of this court. My name is Pastor Jason Douglas, and I represent Liberty Ministries, Inc. I am writing to share my perspective regarding Mr. William Easley, who has been an active participant in our ministry following his recent release from incarceration. Upon returning to the community, Mr. Easley began attending our ministry's programs, including Bible study, Bible teaching sessions, and fellowship activities along with his entire family. His children have been part of our ministry's child care services for the past 2 years. Throughout this period, he has demonstrated a genuine interest in personal growth and spiritual development. In my role, I have become something of a mentor to Mr. Easley. We have had several conversations about his aspirations and his desire to remain involved with our ministry. Specifically, he has expressed interest in participating in our outreach programs, such as initiatives to feed the homeless and street ministry, which are central to our mission at Liberty Ministries Incorporated. From my observation, Mr. Easley has shown marked improvement both mentally and spiritually. He has articulated a strong commitment to being present for his family and to never being separated from them again. Moreover, he is determined to serve his community in ways he had not previously considered. I respectfully ask for your favorable consideration regarding Mr. Easley. We have witnessed positive change in his characters and actions, and we are hopeful for his continued progress. Thank you for your time and thoughtful consideration. Sincerely, Pastor Jason Douglas, Liberty Ministries, 535 South Grant Street in South Bend. Your Honor, I very much join in the comments expressed by Pastor Grant because they reflect the young man that I have come to know, who has not always been at liberty. For 97 days, he was in custody, and I recall spending time with him at the jail. And I think he struck me as a rare person who almost immediately decided this is not for him. And the things he had done to place himself in this position were things he never wanted to do again. We had long talks about his family, about his children. I came to know his father. I believe it's a very genuinely felt sentiment that having put himself in this position to have separated himself from his children, even for the 97 days that he was in custody, have been a very severe punishment for this young man.
Very severe punishment. But, guys, do you eat your Red Hots one at a time or big handfuls? Because big handfuls is how you do it, and that is a severe punishment for me.
Now, when I think about the correct outcome for his case, and I recognized he was charged with a level 2 dealing offense and was able to plead guilty to a level 3 offense, which opened the door for the prospect of a potentially suspended sentence because he does not have a prior felony conviction. That was very considerate of the state. And I think that while he deserves credit for accepting responsibility and pleading guilty, I recognize it has to be weighed against the concession made from the state. However, I can tell you, having negotiated that plea, I think the state saw something similar to what I saw, which is he has no prior felony history and he's a young man. And he has plenty of opportunity and resources to do something differently in his life. So I'd begin first in focusing on mitigation apart from the character letter, his acceptance of responsibility. I remember, I knew this from talking to him, but he told me he graduated from Hyde Park Academy in Chicago. That is a very fine school. I lived and worked in Chicago for a long time. He certainly had advantages as a young man and took advantage of them. He's a worker. He's worked in various different jobs and has ambitions to do his own business. He'd like to pursue further education and to start his own cleaning company, something I think that he would have some skills in, because his last employment before his arrest was working in maintenance for the Candlewood Suites Hotel. I spent a few summers doing that myself, and it's good work. It's early days. It's work throughout the day, but it keeps you focused. He has good family support. He has misdemeanor histories, but not felony histories. The hard thing, I think, with a level 3 conviction is the advisory sentence is 9 years. So this is not an instance where, somebody who's already served close to 100 days in jail might just serve out another few months and be finished with it. But here's what I'm thinking, a way to sort of reflect the seriousness of this offense, but also to reflect the prospect of this young man, would be to do a 9-year sentence that I would divide this way. 3 years served through community corrections, and he was approved for electronic monitoring by Michiana Community Corrections, with 6 years suspended to a period of probation that the court thinks is appropriate.
Not you, Snoopy. I'm saying Linus can't fake being you. There's only one Snoopy. You are the one Snoopy. The FU is to Bread, and I meant it from the bottom of my heart. All the way. F all the way, you. I'm never even touching the package. I had to carry hot wings for years. We don't have hot wings at my job now, thank God. But I had to carry just the baskets to the table. And the smell would get to my nose. I cannot do spicy. I can't do Red Hots. I can't do a big handful of Red Hots, Smurf. I can't. I can barely do Doritos.
What that does is, in the immediate short term, puts him under an elevated level of supervision. In fact, is an executed sentence, where he can, I suppose, prove me right, work and go home for 3 years. It also then would incentivize him for the better part of a decade to remain problem-free by holding a potential 6-year prison sentence over his head. I don't say this lightly. But I'm proud of this young man because from the person I met on day one to the person who has now become employed, even with this case pending, I've seen a real desire to do better than this for his children, for his significant others, and for himself. And when I read his pre-sentence report, I was generally not surprised that he had as good a background as he did, because that was the impression I had on him. I don't want to, minimize the harm that drug sales do, particularly because he's admitted to having knowingly distributed, I think 5 grams of fentanyl over a period of time.
Going?
But I also don't think this was a career choice for him. I think that he was in a situation of some financial desperation and felt like this would be a sort of quick way to earn some money. Well, when you consider
poison children to earn money. Good idea. Great idea, sir.
Separates you from your family and potentially could cause you to face up to 16 years in prison. I think Mr. Easley has learned very quickly that that was an imprudent thing to do that he will never do again. I also think the facts and circumstances are somewhat interesting. I think his luck that when he delivered these bags, which from the lab reports contained a great deal of sugar and baking powder, he delivered them to an undercover police officer. So I think it's his luck that nothing worse happened or that he wasn't involved in this particular trade in a much worse way. So I'm being discursive, but I suppose what I want to express to the court is I'm in a way surprised that a young man like this finds himself here because he has so many tools to not be here. But I think that this has taught him an incredibly significant lesson, which is to use those tools and never put himself in this position where he's away from his children for even one day. So I guess to reiterate, my idea is a 9-year sentence with 3 years being done through community corrections and then 6 years suspended to a term of probation that the court thinks is an appropriate length, Your Honor. Thank you.
What's the state's position?
Thank you, Your Honor. The state does also note that there's several family members, community members who wrote on the defendant's behalf. If the state decided to see family support, that's important. However, if you have a duty to protect the community, in this instance, this case is not a one-time dealing. The defendant sold to the undercover officer 5 times, and it was mostly all fentanyl. The defendant's house was also searched, and more fentanyl was found in total between the buys and what was in his house. Was at least 53.61 grams of fentanyl that was confirmed with lab tests, plus additional bags that were found that were not tested. The defendant also had 2 firearms. The amount of fentanyl here is an aggravator as it exceeds the amount needed to prove a level 3. In addition to the concerning nature of the fentanyl and the sheer number of times he was selling, what's also concerning is that the defendant told the police at the time that he wasn't doing anything major. So at the time of his arrest, obviously, now as Mr. Masters said, he's kind of figured out that this is serious, but at the time of his arrest, he didn't see what he was doing as serious, as a serious problem. He does have an adult history, all misdemeanors, possession of marijuana, resisting law enforcement, lying to peace officer, false identity statement, things of that nature. He is rated as a moderate risk to reoffend. Another concern that the state has is he claimed no substance abuse issues, no addictions to fentanyl, and what he was specifically selling, meaning that he's doing it purely for profit, which is a concern for the state and the safety of the community as well. He received a substantial benefit from the plea, coming down to level 3 without a mandatory minimum, just based on his no prior felony convictions at this time. the state would be asking for 9 years executed, so split as a 4 years to the DOC, 5 years to community corrections, with 1 year of that suspended to probation, or with 1 year following suspended to probation with community service requirements as well.
Thank you. Is there anything that you wanted to say, Mr. Easley?
Yes, Your Honor. I wanted the court to know that I'm a father of 7. I was in a dark place. Like, I take full responsibility for this situation. I had a lot on my back, and I had just lost my grandfather, and I had to take full responsibility of my 7 kids, my wife, and my grandmother. So I was doing things that my mind wasn't on track. Like, ever since I got incarcerated, like, I realized that the harm of what I doing was not right. And ever since, I have became a better person. And I'm 35 years old. This will be my first felony. Like, I don't plan on getting in trouble no more. I take full responsibility. I'm a better person.
All right. So I do recognize that it is your first felony, Mr. Easley, and that your misdemeanors are, not all of them, I wouldn't call them old, but older.
This is why I'm single. All the good men are in jail.
A little removed in time from this offense. And so I do take that into account. Not necessarily a
I think if you have 6 kids, you get the 7th one free.
mitigating factor, but I don't give a tremendous amount of aggravating weight to the criminal history. I do agree, though, that an aggravating factor in this case is the amount of fentanyl that was found in your home. It is far greater than what would have been necessary to prove the elements of the offense in this case. I take into account that there were children living in the home while you were engaged in this activity. And I say that I'm taking that into account because I know it is a statutory aggravating factor that offenses that take place in the presence of children can be considered in that regard. I don't know if any of this took place, I guess, in the presence, meaning that the children were watching you do what you did. But the fact that children were in the home where you had this much fentanyl around the house and guns and all of that, the danger that you put your own children in, you talk about being a father, but you had children then in this home that was just filled with things that could kill them. And when I tell you, having sat here for 13 years in this job, how many cases I've had where children have been significantly hurt or killed because a parent is engaged in the exact type of activity that you are, those are cases that stay with me. And I remember every single one of them. And that could have just as easily been your situation based on the activity that you're engaged in your home with your children there. So I understand now maybe the light bulb has gone on and that you have come to a realization after being separated from your family, what your actions entailed or what your actions, the consequences of your actions. But
No, he didn't.
Those consequences could have been so much worse. And I think also about the fact that, yes, I agree with Mr. Masters that fortunately these 5 instances where you sold fentanyl to undercover officers, that fentanyl was not being distributed into the community. It was being likely destroyed or kept, but not dispersed. But I'm also not naive enough to think that those are the only 5 transactions that you made after you made the decision to start distributing fentanyl to our community. And I have to say, I've as I was reading the pre-sentence report, I had the same thought that,
See, that's your problem, Bill. You're using a bank account to bring in girls. That's not how you bring in girls. That's just not how you do it.
okay, I see a lot of people that come in here that have addiction issues, that are sort of in the throes of a substance use disorder, and the way that they finance that or deal with that is to sell themselves, both for the money to get their own product to use, but also to have product there to use themselves. You were doing this, and I mean, I'm glad you don't have a substance use disorder. I think that's a very positive thing, don't get me wrong. However, you were feeding the addictions of people in our community with a substance that is highly lethal and highly addictive. And so you are putting that out into our community and exponentially, I guess, increasing sort of the misery of people in our community and creating a danger in our community. And I don't know that that is something that crossed your mind at all. And so you made a decision to benefit yourself through the misery of others. And to me, that anyone that really engages in this type of activity, I don't know that there's an understanding of the effect that that has on our community at large. I don't dispute the fact, Mr. Easley, that you have, like I said, had this light bulb moment and that you have thought through, maybe more so now, what I guess thought through really the consequences of your action. You are a high school graduate. I take that into account. You have a good education. You have some history of employment. All of those things are good. And I think that's part of what makes this even sort of more difficult to understand, is that you had the ability to make different choices to support yourself and didn't. So weighing everything that I just talked about, I find that a sentence slightly greater than the advisory sentence is appropriate. I think probation's recommendation of a 10-year sentence is an appropriate recommendation. And so I'm sentencing you to 10 years.
She went over what was suggested.
Probation recommends a period of incarceration. I have to say, Mr. Easley, I agree to some extent with their recommendation. I would change it a little bit. So their recommendation is 6 years executed, 4 years suspended, 3 years in the DOC, 3 years in community corrections. I am imposing instead 5 years executed, 2 in the Department of Corrections, 3 in community corrections at St. Joe County Community Corrections, 5 suspended to 3 years probation. So you will serve 2 years in the Department of Corrections. You have 97 days credit toward that sentence. You'll then transition to St. Joseph County Community Corrections. You'll begin your placement in work release. They will go over with you the rules and requirements of placement with them. If you violate those rules, they have the right to hold you in the county jail for up to 5 days. That can serve either as a sanction for the violation or give us time to figure out whether or not you can stay in that programming. I'm going to order as a condition of your placement there that you complete a substance abuse and mental health evaluation and complete any recommended treatment. You'll also engage in any other programming that they recommend or require of you. You'll start in work release. They can transition you to home detention at any point if they believe that's more appropriate. They could transition you back up to work release. Your placement with them and the level of supervision will be at their discretion. I just do not believe that placing you on home detention right out of the gate, Mr. Easley, for a crime that committed from your home, that you could engage in out of the comfort of your own home, is the appropriate level of supervision right now. You'll then transition to probation. You'll have a 5-year suspended sentence. I'm placing you on probation for 3 years. I don't believe a 5-year probationary period is warranted. As a condition of your probation, you'll continue in any programming that you started under St. Joe County Community Corrections supervision.
I think he's going to.
And you'll also perform 100 hours of community service. The other standard terms and conditions of probation will apply, so you will not use any controlled substances without a valid prescription, use any illegal substances, or consume any alcohol. You'll submit to random drug and alcohol testing and pay for that at the direction of probation. You'll report to the probation department at the times and in the manners instructed. You'll seek employment, maintain that employment. You'll remain in St. Joseph County unless given permission to leave by the court or your probation officer. You'll notify your probation officer of any change of address in St. Joseph County within 3 working days, but must obtain prior written permission if you intend to move outside of the county. You consent to your probation officer visiting you at your home, your place of employment, or elsewhere. You waive any and all rights to search and seizure and agree to submit to a search of your person or property at any time while you're on probation. You waive extradition and agree to return or be returned to St. Joseph County without a hearing. You may not purchase, use, possess, or exert control over a firearm or other dangerous device.
So she got an extra year in there. So this guy's going from DOC to jail to work release, which is they're still locked up in work release. They get out for jail, they come back to probation. And if all he has to do is mess up one time in any of that, and she gets all of that time. She can give him all of that time. So, I mean, chances of him successfully completing it, 100 hours of community service, that's a lot. That's a lot. I don't see them get that much. Oof. All right, we have one more. I don't know. He won't win an appeal. He was selling fentanyl out of his house. This poor lawyer. Not really.
Come on up on Ibarra versus Weatherford.
Morning, Your Honor.
Morning. How are
Morning,
you?
Your Honor.
Morning. This is a motion for continuance?
Yes, Your Honor. It's a joint motion for continuance. Parties have previously mediated this personal injury suit. We were unsuccessful.
Snoopy, wait. This is the best one. You should wait. This is the one you want to see.
At that time, but we have committed to reconvening the mediation on April 2nd. We believe that we were far apart, but we believe that we could actually get this done. The only roadblock at this time is an issue with our attempts to bring in the plaintiff's employer. We have a tender defense and indemnity, and we actually have a lawsuit that's pending in federal court on that. They have a deadline, Your Honor, to make a coverage decision, and I think the deadline is actually today. So we should know whether or not they are going to participate. We think that they will, and we think that their participation in the mediation on April 2nd will help us sort of bridge the gap and get this thing done. If it doesn't, however, Your Honor, I think we go full steam ahead. We maybe do 2 or 3 depositions and get this thing ready for trial. So we're just asking for a little bit of time, Your Honor, in order to get
Well,
this.
let me ask you this. Why would you schedule mediation after your trial docket?
That was the earliest time we could get, Your Honor.
There are hundreds of mediators in this town. You could have easily found somebody that would get you before your March 23rd trial docket.
Yes, Your Honor. We were reconvening with the mediator that we did before since he knew the case. We had a good rapport with him when we thought we were making headway. We just weren't able to get all the way there. We think that this extra piece hopefully will get us over the finish line, Your Honor.
Who did you mediate with?
Peter Taff
I don't get
with
Saturday.
Comal Mediation.
All right. I'm resetting this case for trial on April 6th.
Okay, thank you, Your Honor.
Do not schedule mediation in the future in this court after a trial docket. It will not do well for you. I promise you.
Understood, Your Honor.
Okay, that's the mood he's in.
Ridiculous. Y'all are excused. Have a good day.
Thank you.
Ridiculous. That's the mood he's in before this guy comes up.
Parties here on Proctor versus Rivers. Come on up.
This is Texas.
How are you, Mr. McLaughlin?
Doing well, Judge. How about yourself?
I'm doing okay.
He's not
Good morning, Your Honor. This
well
is
soon.
Pamela Boudreau for the defendant. Good morning, counsel.
Good morning, Ms. Boudreau. How are you?
I'm good. Thank you, sir.
Tell me what's going on in this one.
Well, Judge, we got the case settled a few months ago. The accident did involve a minor. Due to the small amount, me and counsel elected to get the funds issued to the mom in the best interest of the child. We did create an agreed motion for guardian ad litem if the court wanted us to place the funds in the court registry. But we do ask the court to dismiss the case since all funds have been dispersed to all parties.
You've dispersed funds to a minor without court approval?
Yes, Judge, it was my mistake.
How much are we talking about?
It was $2,300.
It's not a nominal amount. How old's the minor?
She's 7, Judge. It was issued to the parent on behalf of the minor. However, Judge, as I stated, it was my mistake. If you would, we do have the motion drafted. We can't place the funds in the court registry, and I will gladly write the check, of course. But it was my understanding that since we couldn't put in an annuity account, since it was less than 10 grand, that we couldn't get a broker to actually approve an annuity.
Ms. Boudreau, how did this happen?
Your Honor, we did settle the matter. We paid it. It did involve a minor, where the alleged damages were about a little bit over $1,000. And we did pay out and settle for a little bit more. It's my understanding that there should have been a guardian ad litem that should have been appointed regardless if the amount was nominal or not. We thought it was with the court's discretion, or so I don't have anything else to say other than that. But we have spoken afterwards and realized that is something that the court would typically do, and plaintiff has agreed.
The court would not typically do it. It would always do it. I don't understand how this happened. Truly.
Honest mistake, Judge.
Not an honest mistake. Have you not tried this sort of a case before?
No, I have not, Judge.
Then maybe you shouldn't be trying this sort of a case.
Yes. Well, I asked colleagues, and this was the advice I had, that if it was under a certain amount, that we could get the case settled. And if it was under a certain amount, that it would have to go in a court.
Well, I don't know what your colleagues do, but they don't sit on this bench. I sit on this bench.
Yes, Your Honor. My apologies again.
All right, I'm going to appoint a guardian ad litem. I do not need a motion. I will appoint it myself today. Y'all are excused. Have a good day.
Thank you, Judge.
Oh, Your Honor.
Yes.
My apologies. Just 1 second. We have this is also set on a March 9th motion to dismiss docket. I didn't know whether or not that would be stricken. I have already filed a motion to appear via Zoom and it was granted, but I just wanted to clarify if that was still going forward on March 9th.
Ms. Travis, do we have a motion to retain on that?
Monica, thank you for the cheers. Why would you want to go back in front of this judge? Why? Why would you ask that? Just try to do everything through motions, written.
Well, at this moment, there is no motion to retain file. The hearing is going forward on Monday.
Thank you, Your Honor.
All right, y'all are excused. Have a good day.
Someone's getting sanctions on Monday. All right, guys. Thank you so much for coming out. I really, really, really appreciate it. Drunken, thank you so much for the gifted membership on Twitch. Thank you. Oh, 5 memberships on Twitch. Thank you, thank you, thank you. Yeah, I do love that judge. I really do. It was nice to see a couple of you back again. I did miss you. I did. I will see you all again tomorrow night. Wait, what is today? Today is Saturday, right? Somebody tell me it's Saturday. It is Saturday. So, no stream tomorrow morning. We're going to stream tomorrow night, or whatever time that is for you if you're not in the United States. It's going to be 8 o'clock Eastern Standard Time, which is about 36 hours from now. Something like that. But I will miss you because that's a long time away. So get into Discord and just chat a little bit so that we can make it. Bye, guys. Thank you.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a